Stephen A. Williams, president and founder of the creditrepairshop.com, and in today's video, we are going to talk about a follow-up video on Henson versus Santander Consumer USA Supreme Court decision. You're going to want to pay close attention to this because this is what made the huge course correction and change and loophole for debt collectors who purchase debt. So now let's get a little bit of the background about the case. In 2017, which was not too long ago, Henson versus Santander Consumer USA Inc., the Supreme Court addressed whether entities that purchase defaulted debts and then seek to collect them are considered debt collectors. Under the Fair Debt Collections Practices Act, the FDCPA, the court unanimously held that companies collecting debts they own are not debt collectors as defined by the FDCPA, the Fair Debt Collection Practices Act, which applies to those collecting debts owed or due another. Keyword, owed or due another. Another is the key word to pay attention to throughout this. Therefore, entities like Santander, which purchased defaulted loans and collected them for their own accounts, are not subject to the Fair Debt Collections Practices Act restrictions. This decision clarifies that the FDCPA's, the Fair Debt Collections Practices Act, definition of debt collector does not extend to debt purchasers collecting on their own behalf, even if the debts were in default at the time of the purchase. The ruling emphasized that the Act's language, the Fair Debt Collection Practices Act's language, focuses on third-party collection agents, not on entities collecting debts they own. So let me first, before we move forward, just so you understand, Santander buys defaulted debt and then they're going out there collecting on it. They don't collect debt for other companies. They collect it only for themselves, even though they did not put out the money technically for that debt. They're just buying debt and collecting on it. Defaulted debt. The loophole and why this whole argument came about was because if you're a debt collector, which technically they are a debt collector, the only difference is that they're not collecting it for other companies, is that they're not under the restriction of the Fair Debt Collections Practices Act, which came about because of threats, because of overuse of the phone, now overuse of internet technology, overuse of email technology, overuse of AI technology, harassment, threats, all of these types of things to get people to pay up. Now, with this decision, a company they're not under the restrictions of the Fair Debt Collections Practices Act due to this Supreme Court ruling. When it first came out, I made a video on this a while back, and when it first came out, it was like this, where companies were not feeling too comfortable about it. They were like, yeah, we're not collecting for other companies. We're buying the debt, but we're going to ease. Don't feel too comfortable because they were so used to, being under the Fair Debt Collections Practices Act before this ruling. But now lately, what I've started seeing from people is that I get a lot of comments, get a lot of emails, a lot of live chats. Steve, I did a debt validation and I got no response. And I was like, the first thing that you need to do is you need to look and see if that company is only buying debt and collecting it for themselves. It doesn't matter if it's defaulted. They could have got it out of a Chapter 11 from another company, or a Chapter 7, or it was transferred because of something that happened with the previous owner of the debt. And they're hitching their wagon on to this Supreme Court decision. So now let's move forward. The arguments that were presented. So let's look at the arguments that were presented and then you can kind of come to your own decision on if you think that this was right or not. The petitioner's argument, Henson's argument, the Fair Debt Collection Practices Act defines a debt collector as someone who regularly collects or attempts to collect debts owed or due another. Owed or due another. So not this, this part about that only purchases debt and not collect debt that's due to others. It's just stated, hey, if you're buying debt and it wasn't your debt, you're technically a debt collector. It doesn't matter if you collected for other companies. Henson argued that entities like Santander, which purchased defaulted debt, fit the intent of the Fair Debt Collection Practices Act because they engaged in aggressive collection tactics similar to third-party debt collectors. Again, these aggressive actions that Henson argued were not just things that just came about in 2017 or came about recently. This was something debt collectors were very aggressive, threatening people with lawsuits that they did not intend to do, which is against the Fair Debt Collection Practices Act. Threatening, calling people by phone over and over, all times of the day, which made the rule about the time frame that they can call you. Calling people who should not know about your personal private information. Now they can't do that without your permission. Calling your family, friends, neighbors, trying to locate you. They can only do that on a limited basis based off of who might be on the applications as a reference, but they can't speak to them about why they're trying to contact you. Calling your job, all of these types of things. So these protections were put in place so it could, not put so much stress on individuals who are in a bad financial situation. So now the purpose of the FDCPA, Henson emphasized that the FDCPA was enacted to protect consumers from abusive debt collection practices. They argued that excluding debt purchasers collecting on their own behalf undermines the Act's purpose, undermines the Fair Debt Collection Practices Act's purpose, as these entities are often more aggressive than traditional debt collectors. Economic realities. Debt purchasers like Santander are fundamentally different from creditors who originally lent the money. They specialize in collecting defaulted debts, which is essentially a debt collection business, even if they technically own the debt. Now, Santander came back with, Santander argued that the Fair Debt Collection Practices Act clearly applies only to entities collecting debts owed or due another. As Santander was collecting debts it owned, it did not meet the statutory definition of a debt collector. Congressional intent, they argued. The law's language, the Fair Debt Collection Practices Act law's language reflects a deliberate choice by Congress to distinguish between creditors collecting their own debt. See how they slipped that in there? Creditor. If we look at the definition of a creditor, that's why this was a little bit greasy in my opinion. Between creditors, they done slipped this word in there. Creditors collecting their own debt and third-party collectors. Santander argued that Congress did not intend to regulate creditors collecting their own debts. Key word, they slipped that in there. Creditors collecting their own debts, even if the debts were purchased after default. Now, they went into this so-called bright line rule. Santander proposed that its role as a debt purchaser collecting on its own behalf creates a bright line distinction between creditors and third-party collectors. Applying the Fair Debt Collection Practices Act restrictions to entities like Santander would blur the line and lead to regulatory confusion. The Supreme Court, in a unanimous decision, authored by Justice Neil Gorsuch, sided with Santander, focusing on the statute's plain language. The court noted the Fair Debt Collection Practices Act explicitly applies to third parties collecting debts for others, not entities collecting debts they own. And remember, creditors. I think that maybe one day this can come back up. Congress could have written the law differently if it intended to cover debt purchasers, but it chose specific language that excluded them. The court refrained from addressing broader policy implications, emphasizing that it was bound by the statutory language and any changes to the law would need to come from Congress. So let me know what you think about this. Post your questions and comments. There's always things that you can do. But I just wanted to make this video to get you up to speed on why some debt collectors that you're dealing with may not be responding to your debt collection, debt validations in a way that you believe they should be responding, but also continue doing that with the enhancers. Make sure you add the enhancers to your debt validation letter, because if they decide to ramp it up and take you to court, that will be the day that they will have to pay for not responding to your debt validation. Trust me. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you early in the game, grab my 3-pack of letters, statute of limitations, debt validation, and cease and desist collection activities letter. Like this video, subscribe to the channel, post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.